Article 231 of the Indian Constitution provides for the establishment of a common high court for two or more states, or for two or more states and a union territory. Here is a breakdown of its key provisions. Clause 1. Provision for establishing a common high court. This clause gives Parliament the power to create a common high court for two or more states, or for a combination of states and a union territory. This is an exception to the preceding provisions of the chapter which generally provide for separate high courts for each state. Clause 2. This clause details specific interpretations and references in relation to a common high court. Subclause B. Reference in Article 227. Article 227 deals with the power of superintendence over all courts by the High Court. In the context of a common high court, the term garner, mentioned in Article 227, regarding rules, forms, or tables for subordinate courts, refers to the garner of the state where those subordinate courts are located. Subclause C. References in Articles 219 and 229. Article 219 pertains to the oath or affirmation by High Court judges. Article 229 deals with the officers and servants of the High Court. In the context of a common high court, references to the state in these articles refer to the state where the High Court's principal seat is situated. Proviso. Special provision if principal seat is in a union territory. If the principal seat of the common high court is in a union territory, the references in Articles 219 and 229 change. Garner becomes Precedent. Public Service Commission becomes Union Public Service Commission. Legislature becomes Parliament. Consolidated Fund of the State becomes Consolidated Fund of India. Summary. Article 231 allows the Indian Parliament to establish a common high court for multiple states or for states and union territories. It provides guidelines on interpreting references to garners, states, and other entities in related articles when such a common high court is established, ensuring that the administrative and legal references are appropriately aligned with the jurisdiction and location of the High Court. The Constitution of India. Part 6. The States. Chapter 5. The High Courts in the States. Article 231. Establishment of a common high court for two or more states. 1. Notwithstanding anything contained in the preceding provisions of this chapter, Parliament may by law establish a common high court for two or more states or for two or more states and a union territory. 2. In relation to any such high court. B. The reference in Article 227 to the garner shall, in relation to any rules, forms or tables for subordinate courts, be construed as a reference to the garner of the state in which the subordinate courts are situate, and C. The references in Articles 219 and 229 to the state shall be construed as a reference to the state in which the High Court has its principal seat. Provided that if such principal seat is in a union territory, the references in Articles 219 and 229 to the garner, Public Service Commission, Legislature and Consolidated Fund of the State shall be construed respectively as references to the President, Union Public Service Commission, Parliament and Consolidated Fund of India.